Yeah. Ah, it worked. And then I just cover you up with my hand. It's like,
Take 3.
all right. Third time's the charm. Mm-hmm. Okay, so I don't know if you guys are aware or not, but we had a lot of technical difficulties with that one. But we're here and we're winning. I am gonna move this down a little bit.
Okay.
That
We're getting the full experience
barely
here.
helped. All right, cool. So what we're gonna talk about today is see if I can move this down a little bit. There we go.
Better?
I don't know. But what we're going to talk about today is we're going to go over some cool hot topics, some juicy goss, and then we're going to go over a couple things because we are the real estate nerds. I guess I should introduce myself first. I'm Eric Rubin, real estate broker and investor, and this is Nancy Wasden.
Hi. I'm a closing
Esquire.
attorney. Yes, and estate planning and probate.
Awesome. So what we're gonna do today is the aforementioned hot goss situation. I'm so bad at using all the latest terms for this kind of stuff.
You are way better than I am.
Right? But some of my friends, I just kind of steal what they say in their posts on social media, and they seem really dialed in. So I'm going to use those terms. But when I say it, it probably sounds like your dad or something saying stuff.
Well, some of them, are you supposed to say them all out loud, or are they just like a hashtag? That's what I've never...
But I think...
You're not supposed to say LOL, right? That one I know.
I think you can. I think it's actually okay to say LOL now. You just don't say V, and you don't say AF.
Right.
Maybe you can say
I say
AF.
AF. I do.
Anyway,
yeah.
So that's super professional. So, and then we're going to talk about what happens when people are unavailable or unable to sign documents, and that's going to be, the less tantalizing information for today. But yeah, it's pretty interesting. It gets into if people are unable to show up to closing, or they they're not they don't have the capacity to sign legal documents, or they are too young to sign documents, and how that would be handled anyway. But yeah, what's up? What you got? Yeah, well, you should definitely check it out anytime I go live, Ryan. I mean, you should just, if you're in a meeting, you just tell people you've got to leave and immediately come to your phone and watch what I have to say. I feel like that just goes for everyone. Anybody I know, they should just drop what they're doing and watch my lives. But yeah, so one of the things I was definitely interested in, and actually Nancy and I were at a training or something. One of your trainings.
Yeah.
And you mentioned it, and yes, you're right.
You can say it? It's in the dictionary. Oh, yeah, I guess so.
Wow. Okay. But yeah, so we were at a training, and I had just seen it on the news, but here in Georgia, I don't know if anybody sees this in your elsewhere, but in Georgia, and you may have to help me remember about this, but there was a guy who was incapacitated. I believe he had some kind of learning disability or mental disability or something.
I think it was something along those lines.
And he was unable to handle his own finances and whatnot, so everything was in a trust.
He was the beneficiary of a trust.
Okay.
And when you don't have capacity for yourself, somebody has to speak for you. And if you don't have a power of attorney, you do what's called a conservatorship through the court system. And he'd either had that already, or they were trying to get that established. And that's when the fake fraudulent forgery stuff came in.
And that's the juicy part, not the good part. So apparently what had happened is was that a relative?
I think it was a cousin or something, or a friend of the family, and they brought in essentially someone who was
it his
posing.
mom?
The mom was, yes, petitioning to be the conservator. She wanted the money. And they had another person, either a family friend or a family member, a distant family member.
Yeah, so the mom brought in a different person that was not her son, that had this that had a settlement or something that they had put in a trust. Maybe I should have read up on this before we got in
I
here.
did.
Ouch. Ouch. Burn. So what happened is she brought in this imposter
Yes,
to
that's
court
the word.
and was trying to get all this stuff done so that she could get access to the money and use it. And it just was not. And then they couldn't find her son, who was the actual person that all of these proceeds and all of these
It was
things should have been going
200
toward.
grand.
Yeah, right. It was
They were
like-
trying to say he was okay now. They wanted to undo the conservatorship because the court watches over those things. If you don't have a power of attorney, they want you to file either a bond or inventory or returns or all of those things. And so they were kind of tired of the court being in their business, and they wanted that money to just do with what they pleased. And so that's what they were trying to undo and go ahead and get. And they came within a breath of having that check written. They really did.
Did they really? I thought they caught that pretty quick.
No,
did
they
not?
went to court. Everybody thought he was the guy, and then the attorney who had been involved with conservatorship kind of all along the way got a little funny about nobody had really seen the guy in a while. And so they asked a few questions, and that's how they figured out the guy that was in court was not the real guy.
Wow.
And
So
everybody was afraid what had happened to the real guy.
or my concern was like, oh man, because I heard another horror story about when I was getting my broker license. My instructor was like, I had a situation where I was a broker. One of my agents had a deal where there was a family, and I guess they had, and I'm not going to get into names or anything, so that way I'm not like telling anything that he's going to have to get like called in for later on, I hope. But apparently there was a situation where the family, they got signatures on all of the, you know what, before we get into that story, let's finish up the one that we're currently on.
Oh, I like it.
My ADD, yeah, that's just a little teaser. But yeah, so they were, my concern is that guy, they had, I watch a lot of ID investigates with my wife. I was pretty sure that they had killed that guy and were just trying to get the money. You have an update?
Just Friday, I think I saw the update. It was happy news that they found him and he's okay. And they didn't disclose where he was at, but that he's doing well in a safe place.
Okay.
So
did they say where he was?
No, they didn't want to disclose where.
Okay.
For, I guess, publicity, all that stuff. But I think he's with family members and he's okay.
Okay.
Yeah.
Well, that's good.
So it was really good. So it was just about the money, not so much about homicide. So
yeah, well, that's always good.
Gonna be good.
Yeah.
That's what it is with real estate too. It's really about the money. Nobody really wants to kill anybody. Actually, I mean, things get emotional, but
yeah, they definitely do. I feel like sometimes it's more about people feeling raw some kind of way, more than it is about money or whatever it is, because I've seen like pretty big arguments come out of very small amounts of money. So I think it's more about like feeling wrong.
I just said
Man,
that to
my
the
whole
clients
family's
today.
on here.
I love
and then, my brother-in-law too. And then yeah, that definitely is something you would do, Lena. I could see that happening.
I just said that to a client today, and I say it frequently, that it doesn't have to be worth a lot of money for people to fight over it. If it's the bowl that everybody's used for the chocolates at Christmas for years and years and years, they will fight over that for sure. Or the teddy bear, or the collection of golf balls, or whatever.
Yeah.
So, yeah, it happens. So you had a story.
Yeah, so the story was that this family, I think they had already sold a property that all of the siblings owned. And then they were listing another one, and they were having some issues, and I think either the title check or the closing attorney or something was being a little bit more in depth. And they found out that so all the siblings had signed off, were signing off, and they're like, well, I guess a brother had been like unavailable, and they, weren't able to get to him. And long story short, although it's far too late for that now. So longer story, less long. Come to find out that my understanding is that sibling was deceased.
Oh.
But they didn't want anybody to know about that because they were still collecting, I think, Social Security or something. But they did want to be able to sell the properties. So they were like, we don't want to provide a death certificate,
more money,
but we want to have both.
Right.
Is what they wanted. And so from what I know, that broker was like, we don't do business with these people. Terminate this listing agreement. Right. We are out.
Yeah. That's gonna be
we do not want to know any more about this.
No.
Because I feel like that's one of those situations where you're just like, stop talking.
Yeah. Right. And lose my number.
Yeah. Lose my number. Stop talking. And anything you were about to say, just scream it into a pillow.
Well, unfortunately, that is a somewhat, I hate to say popular way, but that sort of thing happens frequently. And that's why when anyone is deceased on title, probate work anymore is all but 100% required. Because you have unknown heirs who are out there. And if you haven't done the probate process and done the publication or served everybody and had people on record notarizing and swearing to the court that these are all the heirs, and them being on the hook for it that way, then you have these massive title claims. I mean, that's a pretty massive title claim. You have an entire heir, and not just an heir, a dead heir who then has his own heirs that have a claim now on your property. That's going to be superior not only to yours, but of course any lender that's been involved and all that. So that's why closing attorneys care about probate and who everybody is, and anybody who has ownership percentage needs to be sitting at the table in some form or another. Yeah. Which is kind of a good segue into unavailable or unable. What happens if you can't be sitting at my table? How is it that your interest is represented, and how is it that you're sitting physically there? Because that's really what it's all about.
Yeah, that's a perfect segue. It's almost like I planned it.
It is. But you had some really great examples of times that you can't be there.
Yeah, I mean, I've had situations where people are just out of town, or they're on the other side of the planet, or whatever it is. In that situation, you could either do a mail away or a POA. Mail away being you send all the docs electronically, or I guess you could send them physically, but I feel like people never do that.
People don't do that as often, but some people need the little flags, the sign here.
Okay, that makes sense. So then people print those off. They go to a notary.
You
prefer them
a
to
closing
be at a closing
attorney's
attorney?
office or a title company or something like that. But
especially if you've got like a sister office in that place, to where they go there.
Yes, that's my preference. But people have been known to go to a UPS or whatever. The problem is if they're out of the country and you need a U.S. notary. Have we talked about this? I can't remember.
I feel like we did, but I don't know where it was, so I don't know if people have that information.
So the notary has to be a U.S. notary, and there is something called the Hague Convention, where there are a lot of countries that are all together in that, where we don't need you to go to the embassy if you're in one of those countries. That is Googleable. Is that a word? I just made it up.
It is now.
It's on the gsccca.org. That's an easy place to find it for you real estate people. So if you're not in the Hague Convention, and for example, Canada is not, and you would think that they were, but they're not. Sadly, you have to either find somebody who is there, like if I was in Canada, I'm a U.S. notary, right? But more often you end up at the embassy. And that is not something people are used to or know how to do. And in some countries, you have to make an appointment, and they are booked for weeks and sometimes months.
That sounds like, in that situation, you would just be on social media and be like, who do I know that's going to be in this area? Who's on vacation or whatever it is?
Right. And the problem is whether you do a mail away, which does have at least the deed has to be notarized. Often it's the owner's affidavit that's on the seller side. Buyer side is going to be more difficult if you have a mortgage, but if it's cash, there are still some things that are notarized. And what else was I going to say? Oh, a power of attorney you could do would make it easier, but that also does have to be notarized.
So, but the simple version of a mail away is mailing or emailing documents to that person. Let's say they're within the United States. They take those documents, are in front of preferably a closing attorney, but maybe a notary. They sign those documents and they FedEx them back. Usually, all that stuff is sent by the attorney. There's like a FedEx label in there. You print that off at the same time, get it signed, send it back. So when that document lands and the other signatures are done, then, I guess there's
It's like the pieces make a whole puzzle.
Yeah, I mean, I guess a lot of times they'll put like a separate signature page so that you can just put it all together, so it's all wet signatures all together. But anyway, that's the gist of a mail away, is like it is what it says. Yeah. And then a POA, a power of attorney, is you having the. Why am I? I'm sitting next to an attorney. Why am I explaining this? I feel like, and then I'm just like, I feel like there's so much pressure.
No, you got it. You're good.
Okay. Do you want to just like call me out on stuff that's wrong?
No.
Oh, okay.
I think I did that like once at least already.
Oh yeah, for sure. Yeah, you definitely should. I mean.
No, it's where you give your power away, right?
Yeah,
You're so funny. And especially for a real estate deal, we like them to be specific to the property usually, but a regular or a general power of attorney can be used as well. And it's where you're giving powers that you would usually have away to others. There are some powers that you can't give away, but there are plenty that you can in real estate transactions, and the ability to contract are included in those that you can.
Yeah, I feel like there's always there's a few jokes that I feel like real estate agents, brokers, investors, and attorneys always make at the closing table. There's the if you don't pay, you don't stay.
Yeah.
There's the rhyming joke there. And then there's the joke if somebody's a power of attorney and they're signing documents for someone that they know or something like that. At least one person will make the joke that if you do this any other time, you're going to go to jail.
Oh, that's weird. I haven't heard that. Usually I get the like, oh, are they paying you for this? They owe you a beer, that kind of stuff.
Oh, no. I usually,
jail.
Yeah, it's like, don't do this any other time. Like, don't get in the habit of this.
Oh, right. Yeah.
And then as they're signing.
Yeah.
But also, it's a good reason to make it specific to the property, because otherwise they could.
Yeah.
I mean, if you made it just for real estate transactions, like you could go buy a house real quick.
They could.
Doesn't seem like a good idea, but I guess technically. So we covered mail-aways, power of attorneys, and then kind of the tougher stuff is going to be like those conservatorships and trusts, where it's going to be somebody that's, if it's somebody that's not there, then that's one thing, because they still have the capacity to give.
They can still sign it. They just can't be there.
Yeah, exactly. But if someone is not capable of signing documents, then again, this comes back. I feel like this is just a thread that runs through all of our videos and whatnot. Is that planning ahead of time is everything.
Yeah.
So if for instance, my mom is. She has dementia, so she's unable to sign anything.
As an example, anybody who has dementia to a certain degree would not be able to engage in any type of legal relationship, be it a contract, be it consenting to certain treatments, even healthcare-wise, or all of that. There are different tests and different legal standards depending on what you're dealing with, but that's what you're talking about.
And hopefully before that cross the threshold, which I feel like is such a fuzzy line.
It is.
It's just like, how comfortable does an attorney feel like doing this paperwork, and at what point are they past that point of being able to give that power of attorney or conservatorship? But that's why I mentioned planning ahead, is hopefully you've planned ahead. You've talked to your attorney to where before they were past the point of not being able to have the capacity to give that power to someone, then that power was given to someone, or set up a trust for that person. And the trust is the thing that you corrected me on before, because that would be the beneficiary and the trustee and all that kind of stuff.
So in a trust, there are a couple different roles. The trustee is the person who has the power to do all of the decisions, to sign the checks, to say yes or no, to spending money, to disposing of property, to investing, those sorts of things, closing accounts, opening accounts, paying taxes. And then the beneficiaries are those who benefit from the trust. So, for example, if I think my husband and I have it set up where if both of us are gone, we have a trust for our children. The trustee is somebody who makes that decision. That could be you, right? But my beneficiaries are my kids. And so they are the ones who, they do actually own the property. It is theirs. It belongs to them. But the trustee is the one with the power over it to handle its disposition, because they're 14 and 11 and they'd have some awesome ideas that involve GameStop and online gaming probably of ways to spend it. But it's the grown-up that has say-so over it.
Well, with esports becoming such a big thing,
Right.
I mean, they might make some decisions that allow them to go pro, and
Right.
then they're
Yes.
doing great. They're living the dream.
Open a YouTube channel, whatever it
There
is
you
teenage
go.
boys
Yeah.
like to do.
It's like, who would have guessed that Twitch would be a thing that people are making money at? You get to watch me play video games. It's like when you're in second grade and
Yeah.
your friend's playing a video game and you're just watching them for like an hour.
Incredibly boring. Whenever I watch them, I'm like, this is what you watch? And they're like, no,
Shh, quiet.
yeah.
We're whatever that game is where they Minecrafting.
Oh, yes, yes. There's a lot of them. So that's the difference. Person making decision is the trustee, and then beneficiaries. And it's similar to a power of attorney. There is the person who gives the power of attorney. That's kind of the founder of the power of attorney. And then there's the agent who actually carries out what's in there.
I'm just thinking about all my mnemonic devices I use to get through my testing. Like Silas McGree, the mortgagee from Rocky and Bullwinkle. Because
like
he
that.
was always the bad guy.
Yeah.
Because the mortgagee, that's the what's called
I'm not
the
sure which way
one
you're going.
situation where
Yes.
like trustor, trustee, it's like because one is giving to the other.
Yes.
But mortgagee is the reverse of most other notes and whatnot. Am I tripping?
Oh, I think I know what you're talking about.
Because usually the trustee is the receiver, yes?
The trustee is the overseer. The beneficiary is the receiver. I know what you're talking about, though, because
Well, I mean, as
it's
far
like...
as the suffix. Because when you're doing like a trustee, it's a different situation. Like
Yes.
because the mortgagor is the person
Yes. The borrower.
because they're giving back
Yes.
a paperwork, whereas in the other situations, like the grantor grantee, then that's
Yeah, the mortgagee is
grantee
kind of
would
backward.
be the receiver of the property, whereas the mortgagee is the receiver of the note.
Yep.
So it's the one situation where it's backwards.
I like that. Okay. I got it.
Yeah. So I always think of, and I think I got that from somebody in California whenever I was initially going through that stuff. So anyway,
How fun.
so everyone's gone. Like everyone just got bored. Okay. So where were we? We were talking about
We
power
did
of attorney.
unavailable for
yeah,
power of attorney.
we did
and
unavailable, and now we're doing
Unable.
unable.
And we got into trusts a little bit.
Sort of trust and that kind of stuff. So it's
Yeah.
and we talked about one. I feel like probably the most prevalent one is seniors, which and for me, obviously, with my situation, it's an important one to me. But I feel like with so many baby boomers retiring and going into assisted livings and doing all those kind of things now, I think that's something to look at and before they start going into those places, you need to have either a trust set up or something set up to where you're able to make decisions for them, somebody trustworthy or a couple people trippingly off the tongue, then a couple people to be able to make the decisions for their financial needs and make those decisions for them, because you don't want to come to a point to where they're incapable of making those decisions for themselves. They can't sign for stuff, but also neither can anyone else.
Yeah.
Because at that point, you just have to get the court to approve everything.
Yes. Well, so a trust and a power of attorney operate very similarly, where you are giving power away to someone else. When you establish a trust, it's like a family company. It owns everything you own. You are the initial trustee, so you have decision
Is it all right if
power.
I interrupt you for a second?
Sure.
Okay. One thing I will say is that banks do not like power of attorneys.
No, they don't.
So if you have an older family member, then you need to do more than a power of attorney is what I would recommend based on my experience. My anecdotal experience and my sister's experience of going to the bank a million times.
A million times.
Especially after moving to Louisiana that is Napoleonic law,
Oh.
and not having my mom's bank anywhere near there.
Oh man.
Like when she was back in where she had moved from, she had to get everything done, and then they still messed it up again. So it's like she tried to do it initially, tried to do it before she left because she knew it would be a problem after that.
Right.
And then she tried to come back and do it when she was going to be there for a different reason.
Right.
But yeah,
That is not
so power of
sadly
attorney
an
is
unusual story.
banks aren't super excited about power of attorney. So
No.
please go ahead.
Yeah, it's not an unusual story, sadly,
Yeah.
that banks can be very difficult, or financial institutions in general. Closing attorneys can be picky about it too. We like to see them within a year. I like to see them specific for closings. Powers of attorney in general just need to be, we like them the more recent they are, but part of the problem is you may have an illness or something that's going on for a long time where we can't re-execute a new one. I will say there is a new one in Georgia. It came out July of 2018, so it's still quite new. And part of what was done in creating that power of attorney is that it's supposed to be accepted mandatory by the financial institution. You bring them that document and they are supposed to have to accept it. If they don't want to, there is a process in place and time limits. So they can say this is what's wrong with it, and they have 3 weeks to tell you or 30 days to tell you. It's spelled out in the statute.
But the work is on their side. It's
Right.
not on your side to fix it for them. It's
Right.
on their side to tell you why they can't.
I believe so. It's been a minute since I read the statute, but that was pretty much it. Like,
Okay.
these are the reasons, and they have to tell you within a certain amount of time. They can't just hold it forever and get it tied up in their departments and things like that.
Because that's my issue with like plausible deniability and like, is it safer for me to say no than it is for me to go ahead and say yes? And I feel like if you're in certain situations, if you're unable to give me a yes, then why am I talking to you? And I feel like that goes in a lot of situations. I'm way off topic now.
No.
But if I'm a person working at a bank and it's safer for me to just say no, and then I'm not on the hook for anything,
Right.
and I don't have to do any work beyond that, and then you can bring me more stuff so that I feel more comfortable saying yes,
Right.
then I'm probably going to say no.
Right.
But if there's a situation where if I say no, I've got to tell you why, then if it's on me as the bank guy to do that, then I feel like they're going to do more there. I don't know if that made any sense at all.
It does. And they had input.
And while I don't want anybody to be able to defraud people, I
Right.
also want people to have an opportunity to get things set up to where
There has to
it
be
works.
options for it to move. Like you said, either it's yes or no, but just being stuck in the middle of not being sure is where the problems were happening.
Yeah,
like either
absolutely.
we can do this or we can't, and bringing them more stuff. And the thing is, sometimes the situation is such that you can't bring them more stuff other than maybe a doctor's affidavit or something like that.
Oh, also, we forgot to give this disclaimer earlier, but
yeah.
you should not take any of this as legal advice.
You're way better at that than I am.
Yeah.
I forget that every time.
Yeah.
Yeah,
Well,
this
as
is all
long
very
as it's in there
general.
somewhere.
Yes.
Yeah. This is if you have specific questions, we're gonna have Nancy's contact information in the comments, and if you have questions for me, then you can just message me or whatever you got. And then if you have a situation where you have a family member, or you are looking to sell a house, just give me a call and we'll get you fixed up. So we've got the
So the power of attorney for the unable can get tricky because if it's in place for a long time, it's old, it doesn't have this or whatever, but that's sort of a best effort. If you don't have a power of attorney and also I think I was talking a little bit about how a trust functions as a power of attorney as well. It takes
also,
over
so,
upon
sorry.
capacity.
If any of you guys have any questions throughout this, go ahead and throw them out, and we can stop. You don't have to wait for me to ask a stupid question of Nancy. We can ask your questions too, which may be better than mine.
You never know. So a trust will take over upon incapacity where it owns everything you own. You are the initial trustee, and then when you are unable to function as the trustee, be it either unavailable or unable, it covers both, then it will function like a power of attorney that way. And then a power of attorney also will take over or last over incapacity if it's a durable power of attorney. It's kind of silly that one little word does have to be there to make it valid all the way through. any period of incapacity. It does die with you, though. That very moment that someone passes away, the power of attorney is garbage. So that's one good thing to know. But it may be usable for a little bit or for a really long period of time, depending on the situation. But that's unable. Now, what if we don't have a power of attorney? What if we don't have a trust? What if we don't, have
no
a way?
conservatorship or anything
Right.
like that?
Well, that is the answer, is the conservatorship.
Okay.
That's really all there is. Now, there are two types of this sort of thing in the probate court. One is a guardianship and one is a conservatorship. The guardianship is healthcare stuff, right? When we've got to talk to doctors and deal with treatment. We're talking more about the conservatorship, and that's money. That's going to be anybody's property or their money or anything.
And typically those are done at the same time?
They can be, depending on what's going on.
If it's like a elderly parent or something, you would do your conservatorship and guardianship at the same time?
I think it depends on what's going on. And all of these situations are so very fact-based. But they do have emergency guardianships and conservatorships because it is a fairly long process. It takes a couple of months. You got to have some testimony from people around them proving the incapacity. Sometimes they want them to come to a hearing, which is where you bring the actual person and not a fraudulent stand-in imposter. So yeah, depending on what all is happening, you may go ahead and file them both at the same time. But if you've got something urgent that needs to be handled either healthcare wise or selling the house, if that's really what we're dealing with, and we're dealing with a possible foreclosure or something's happening where we need to get something handled there, then a conservatorship would be the way that you would go.
Yeah, I mean, I've actually got a good question for you right now. I was speaking with some folks, and the brother was in a car wreck, and so now has some disabilities. His then roommate is still renting the property from him. I don't know exactly what they've done with the property.
Okay.
And he's in assisted living.
Okay.
And now they want to sell the house, and I think it may be in a trust. The brother may be in charge of the trust. I don't know what else they need to do in order to sell that property.
Well, you got a couple
it
issues,
hadn't
right?
come up yet.
Right. There's a couple issues would be, first of all, the brother that's in a facility, just because he is physically disabled, that doesn't preclude him from handling his own financial affairs. So there's a capacity question right there, is would he be able to sign a listing agreement with you, for example, or a purchase and sale agreement, or both is really what we'd have to deal with. And if there's any sort of brain injury that we're dealing with. And there's also something called a lucid interval, where they have sort of good days and bad days. That's not going to be my preferred situation for anybody, and if you all realty-wise dealing with it, because proving that, he knew what day it was and what he was signing that day, but today he doesn't, is a problem. So capacity question first, lease question second, and or title question. Before you sign anything, you got to know how it's titled. So if it's in a trust, that's fine. We want to know who the trustee is. If the trustee is brother and he's in a facility and he can't deal with it or doesn't want to, then I want to look at the trust and see if there's a successor trustee that we know for sure has capacity. We'll go ahead and get a resignation or some sort of acknowledgement that this trustee isn't serving anymore and we're dealing with this guy or gal, and go that way. And then I also want to address the lease and see what's happening there. If there's an eviction process, if it's any good still, if it's sort of rolled over to month, and also from a practical perspective, kind of talk to the roommate and see what the situation is.
Yeah, I mean, and certainly in another situation where that could get contentious. It sounded like this is not that. It's
right.
Somebody was like, "Oh, okay, well, I need to be out by a certain." Okay, cool.
That's always nice when you don't have to evict people.
But yeah, I mean, these kind of situations are complicated enough without like the emotional stuff going on.
Yeah.
But yeah, so I mean, so that's interesting. So yeah, as far as capacity to sell, we did bring up the fact that plan for this stuff ahead of time.
As best.
Yeah, as best you can.
Yeah.
And then I think, did we cover what we needed to cover on seniors? Is there anything else you wanted to cover before we go to minors?
I think we kind of covered under seniors, all of these things would apply. We could do a mail away, a power of attorney, have it in a trust, or deal with a conservatorship. Those are sort of all of our options.
So what I thought I heard you say before is that if, just a review for folks that didn't catch the beginning, or myself that needs to have it spelled out in crayon large letters. So if someone does not have any of the power of attorney, none of that set up, and then they're past the threshold to where they are incapacitated, they are not in a, what was it, a lucid state or a lucid interval?
Mm-hmm.
Okay.
Good. He listens.
I do. And then, so they don't have lucid intervals to where they would be able to come in for, like, on a good day.
Right.
At that point, you would need to set up a conservatorship after the fact and, take the 2-3 months to go through that process.
Mm-hmm.
And
I just plan for it, and the expense.
Yeah.
And the thing that's a real bummer about the conservatorship, or I think is kind of a bummer, is the bond that you need to post. And it is what it sounds like. It is money that you put up, or assets or something that is typically a percentage, or different companies work at different ways, but you have to have skin in the game, essentially, because you weren't nominated by this person that is incapacitated. We don't know what they want and who they trust because they can't speak for themselves anymore. So part of what you would do if you are serving as that conservator is to post a bond with the probate court that is a certain amount based on the assets that you're dealing with, which are probate assets, and typically it's the house. Mm-hmm. And that is something that just gets posted and has to hang out there until it's finished. Not only that, but you have to report to the court.
by probate assets, do you mean like it would essentially go through a probate process before they passed away? Well,
yes. I mean, there are assets, for example, if something is joint, then we don't really need a conservatorship over that because you have somebody else on that account that's handling it and would be entitled to it should they pass away. I'm talking about the assets that are solely in that person's name that we can't do anything with. Like the house, if it's just in that person's name, nobody can sit at my table and sign for that. We need to get somebody vested with those powers to be able to do that.
So you would get a conservatorship and go through a probate process to put it so that the conservator could do something with that property? Mm-hmm. Okay.
And the conservatorships and guardianships are handled through the probate court.
Okay.
So nobody's died, but it's just, incapacity.
Yeah, that makes sense. Okay. Yeah,
so,
I think
that covers it pretty well.
That was very in depth.
That
was good. It's especially it's nice when I've got all my little like anecdotal situations that I can ask questions from. And then minors. So a minor, once they turn 18, was it 6 months or 9 months after that they could back out of a deal?
Oh, about a year. So, and that's specifically for deeds. Deeds to minors are voidable, which means if I were to sign over my house to my kids, that is not valid, or it's voidable, which is one of the worst types of void.
Yeah, right. Voidable, meaning it's up to that person.
Right.
They can decide whether this is a good thing or a bad thing for me, and it's a one-sided decision.
Yeah. Oh, we're printing.
There's a ghost in the machine.
So voidable is no good. What that means is that they can turn around and decide that that's not something they wanted because they didn't have the capacity to say yes or no. Are most people going to want to get a house given to them? Sure. And that one is for deeds in particular. I think it's up to a year after they turn 18 because they may not know about it on their 18th birthday. So we give them a little time. Should I grab that
in case somebody comes in here for it?
No, they can get it.
They
got to walk right here. We'll make him say something.
Oh, okay.
We'll like haze him or
good.
Something.
Yeah. That's amazing.
Wow,
you're really into this.
I have ideas. So.
Okay. There's a streak in you that's like a little bit mean.
I know, right?
Hey, what's up, Kelly?
So that's how all that goes, and it's can be kind of complicated. It's all a little bit complicated. But.
So as far as minors, it's
contracts,
voidable.
It's the day of 18. You can open a bank account the day of 18.
Okay.
Where you could buy a house or sell a house.
And then the other issue with minors is they're not able to sign for anything. So that's another situation where it's good to have a trust, yes?
Yes. So I will say for the real estate world, you don't come across minors trying to buy and sell houses very often, right? I do see people wanting to put minors on there because they are one of the only ones in the family with a social security number or something like that. But not very often do you encounter that. You may encounter minors who are beneficiaries of some a trust. And I guess we didn't really talk about that, but they could be somewhat owners of a company or a family limited partnership. There are various ways that minors could have an interest, not an ownership necessarily, but they are a beneficiary, like we were talking about, where they own it, but the trustee has the decision power.
What's that George Clooney movie where they own property in Hawaii?
Oh, that's The Descendants.
The Descendants.
That's
like your wheelhouse.
Yeah. It is the whole thing. Yes. And they had to sell the property because it was going to run afoul of the rule against perpetuities, which is this whole real estate law thing that only comes up in Hawaii because people hold land a really, really long time. Not only Hawaii, but it happens over there more often than you would think.
Yeah,
because it's been in families for generations.
Yeah, exactly.
Yeah. It's a good book too.
Yeah, really? All right.
See, and then this is the nerd section.
You're a multifaceted
I'm a mean
individual.
nerd.
All right, so that's minors. Is there anything else we need to cover with minors?
What is nice about it is if you have minors who are beneficiaries or otherwise have ownership interest somehow and it's set up properly, it's going to be the trustee's problem. You have somebody to sit at my table, I write them the check, and then it's their job to handle it and whatnot. It's not on
And
you,
the
the
trust
realtor.
would have it set up to where this goes into an account, and when they're 21, they get this percentage. When they're 25, or however it's going to be doled out.
Yes.
And over whatever time. Okay. And then I think that was about it.
Those
Is
were
that
our
it for
top
minors?
ones. Yeah.
All right, cool. All right, well, guys, that's been it for the day today. We covered a lot, and covered some juicy details, spilling all the tea.
I love it.
So thanks for hanging out. Thanks for watching it. And Kelly.
Thanks. Thank
Oh,
you.
yeah.
I love doing the CE classes.
Yeah. I like going to your CE classes. They're very
Yay.
informative.
I have one on probate coming up. You're coming.
Yeah, I'm coming.
Yeah,
I'll be there.
that's right.
I'll be there. So check out Nancy. Go to. Do you have a website or something for your classes?
I have a I do. Legalese Real Estate School. Yeah, we're on Facebook.
Check out Legalese Real Estate.
Yeah.
Hey, thanks, Ryan, man. I appreciate it. And then if you have a property that you're looking to sell, if you got an older parent or something like that, and you guys are needing to liquidate that asset, then give me a call. Happy to help out. And then if you need real estate questions answered, go to my good friend Nancy. And thanks for hanging out with us. Any parting words?
I think we're good. Thank you. This
All
is
right.
fun.
Thanks for hanging out. If you have any further questions, go ahead and post them here, and we'll get to you as soon as we can. Have a great rest of your day.